Hi viewers, welcome back. We will discuss about air laws. Air law is a general viewpoint that covers the special characteristics and demands of aviation industry. There is no governing body with the right to frame the air laws. So, in the legal sense, there is not any international law. But the phrase air law is used to describe the system of implicit and explicit agreements related with air transport. These agreements are known as conventions. International agreements, if accepted by member state through their legislative assemblies with or without modifications, will shape into national laws. This process is called ratification. There are numerous conventions such as Chicago, Rome, Tokyo, Geneva, and few more. Let us discuss more about the aviation law. The aviation industry has been highly regulated under national and international regulations and various agreements due to inherent safety risks associated with operation of an aircraft. Aviation provides the only rapid worldwide transportation network, which makes it essential for global business. It generates economic growth, creates jobs, and facilitates international trade and tourism. Air laws are framed to ensure highest levels of safety and security and the principle of fair and equal opportunity for all states and their stakeholders. So what exactly is air law? Air law is a branch of law that is concerned with air transport operations and all the associated legal and business concerns. This is a series of rules that governs the use of airspace for aviation and its benefit for the general public and nations of the world. Paris Conference 1910. This was the first attempt to set the air law when German air balloons repeatedly trespassed over French territory. The French government wanted both the governments to come together to form an agreement to resolve the problem. The Paris Conference of 1910 was to address the issue related to respect the sovereignty of states in space above their territories. Sovereignty is the right of a country to impose national law to users of the state's territorial airspace. The 1919 Paris Convention. The technical developments in aviation arising out of World War I created a completely new situation at the end of First World War, especially with regard to the safe and rapid transport of goods and persons over long distances. It had become much more evident that this new and now greatly advanced means of transport require international attention. This was the time when commercial aviation had just started spreading its wings. But how to address the issue related to sovereignty of one state and economical conflicts in such international operations? Paris Convention contains 43 articles organized in 9 chapters as well as 8 annexes. Chapter 1 deals with the general principles. This chapter defines that each nation has absolute sovereignty over the airspace overlying its territories and waters. Chapter 2 deals with the nationality of aircraft. This chapter describes the rules of nationality and registration of aircraft of member state. Chapter 3 is about the certificate of airworthiness and certificates of qualification. This chapter deals with aircraft certificates of airworthiness and crew certification. Chapter 4 deals with the admission to air navigation over a foreign territory. This chapter explains the rules applying to aircraft flying over the territory of another member state and the rights of countries overflown. Chapter 5 is about the rules to be observed on departure, when underway, and on landing. This chapter explains the documents that aircraft must have in all circumstances: certificate of airworthiness, registration, patents and license of the crew, nominative list of passengers, manifest of goods, logbooks. It also lists the obligation and rights of state concerning aircraft flying over or landing on its territory. Chapter 6 deals with prohibited transport. This chapter explains that transport of weapons or ammunition is prohibited over another country. It also makes it possible to prohibit or regulate the transport of cameras or other objects, provided that other member states are warned. Chapter 7 is about state aircraft. This chapter determines which aircraft are considered private or military and which rules apply to military aircraft. Chapter 8 discusses International Commission for Air Navigation. This chapter determines the composition of the international body to regulate civil aviation. Chapter 9 is about the final provisions. This chapter brings together various articles dealing with the rights and obligations of state, how to settle dispute, and the possibilities for other states to become signatories of the convention. The Paris Convention of 1919 is no longer in effect and is now part of history. The Paris Convention was superseded by Convention on International Civil Aviation, which is also known as the Chicago Convention. However, it is pioneering contribution to the formulation of some basic concepts of air law survives and maintains its relevance. The Warsaw Convention is one of the most widely adhered and litigated treaties in the world. Originally signed in 1929 in Warsaw, it was amended in 1955 at the Hague, Netherlands. Finally, the Montreal Convention, signed in 1999, replaced the Warsaw Convention. Warsaw Convention 1929 is the convention for the unification of certain rules relating to international carriage by air. This convention established the internationally liability of air carriers and the monetary limits of damage, delay, or loss. Article 17 of this convention states that an air carrier is liable to death or injury sustained in an accident on board the aircraft. Article 22 of this convention states that maximum ceiling on the damages recoverable from an air carrier when a passenger has been injured or killed in an international air travel was 125,000 francs, which was equivalent to 8,300 US dollar of 1929. Warsaw Convention was amended by Hague Protocol in 1955. Amendment in Article 22 doubled the compensation limit to 250,000 gold francs, which was 16,000 US dollar equivalent in 1955. Warsaw Convention simplified the requirements for tickets and baggage checks and made carrier liable for pilot error. Guadalajara Supplementary Convention 1961 defines who is the actual carrier and contracting carrier, and it also defines the liability of the carrier. Montreal Agreement 1966. It was an agreement on liability among air carriers operating passenger transport to, from, or with an agreed stopping places in the United States. The parties have de facto amended the application of the Warsaw Convention as changed by the Hague Protocol 1955 by providing for a limit of liability for each passenger in the case of death or bodily injury of 75,000 US dollar, inclusive of legal fees and cost, and 58,000 US dollar exclusive of legal fees and cost. Guatemala City Protocol 1971. It limits the liability to 100,000 US dollars for passengers and baggage to passenger except if it is proved that claimant has done willful damage or passenger injury or death is due to the illness of passenger. The Montreal Protocols 1975. The 1975 Diplomatic Conference on Air Law drafted and adopted 4 protocols to the Warsaw Convention. The protocols did not raise the limit of liability, but changed the expression from Poincare francs to special drawing rights, as defined by the International Monetary Fund. Montreal Convention 1999. The Montreal Convention, signed in 1999, replaced the Warsaw Convention. The purpose of Montreal Convention was to consider a new convention to modernize and replace the existing Warsaw system of liability. Exception to Article 21. Carrier will not be liable for damages arising under Article 17(1) to the extent that they exceed for each passenger 100,000 special drawing rights if the carrier proves that such damage was not due to the negligence of the carrier or such damage was solely due to the negligence of a third party. Liability limit for delay, baggage and cargo, Article 22. Liability of carrier towards delay to each passenger was 4,150 special drawing rights. Liability of carrier towards baggage loss, damage or delay to each passenger was 1,000 special drawing rights. Liability of carrier towards cargo loss, damage or delay to each passenger 17 special drawing rights per kilogram. Insurance, Article 50. The Convention imposes a duty upon the contracting states to require their air carriers to maintain adequate insurance covering their liability under the Convention. The determination of what constitutes adequate insurance appears to be left to each contracting state. As per Montreal Convention 1999, a fifth jurisdiction to the fourth retained from the Warsaw Convention was created. The fifth jurisdiction is the territory of the state in which a passenger has his or her principal and permanent residence at the time of the accident. The Convention on International Civil Aviation, known more commonly today as Chicago Convention. This landmark agreement established the core principles permitting international transport by air and led to the creation of the specialized agency, the International Civil Aviation Organization. The Chicago Conference signed an interim agreement which foresaw the creation of a provisional International Civil Aviation Organization to serve as a temporary advisory and coordinating body. The Chicago Conventions accomplished a transport agreement that include an agreement by the signatories to grant each other two of the so-called 5 freedoms of air transport, the right to fly across other states without landing and a right to land for non-traffic purposes. Similarly, this Chicago Convention accomplished the International Air Transport Agreement, which established 3 commercial freedoms. In addition, the Chicago Convention established the International Civil Aviation Organization to regulate the safety, communications, and technological aspects of international civil aviation. Since the Chicago Convention, international civil aviation rights have developed primarily through a series of bilateral agreements between various states. Freedom of air rule emerged from the Chicago Convention in 1944. The freedom of air means a country grants airlines of a particular country the privilege to use or land in another country's airspace. The signatories to the convention decided to set rules that would act as a fundamental building blocks to international commercial aviation. The convention provides 9 freedoms of air, but only the first 5 freedoms have been officially recognized by the International Civil Aviation Organization. The International Air Service Transit Agreement established 2 technical freedoms of the air, and the International Air Transport Agreement established 3 commercial freedoms. First freedom of the air, overflight right. A carrier of one country can fly over the territory of another country without landing. Second freedom of air, technical landing right. A carrier of one country can land in another country for non-traffic related purposes, such as refueling or technical halts. Third freedom of air, commercial traffic own country to another country right. A carrier of one country can pick up passengers and cargo from own country and carry them to another country. Fourth freedom of the air, commercial traffic another country to own country right. A carrier of one country can pick up passengers and cargo from another country and carry them back to its own country. Fifth freedom, beyond rights. A carrier may transport passengers or cargo between foreign countries as a part of service which originates from home country and carry them back to its own country. Sixth freedom of the air. A carrier may pick passengers or cargo originating in one country and carry them to a third country via its own country. This freedom can be seen as a combination of the third and fourth freedoms of the air. Seventh freedom of the air. A carrier may commercial service between two foreign states which do not connect to its home country. Eighth freedom of the air. A carrier may transport passengers or cargo between two domestic points in a foreign country on a flight that either originates or ends at the carrier's home country. Carriage of cargo between 2 points within a country by a vessel or vehicle registered in another country is known as cabotage. Ninth freedom of the air. This is also known as standalone cabotage. A carrier may transport passengers or cargo between two domestic points in a foreign country that does not have to touch the carrier's home country. Now we will discuss about Rome Convention 1952. This convention deals with damage caused by foreign aircraft to third parties on the ground. The liabilities in respect of loss of life or personal injury shall not exceed 500,000 francs per person killed or injured. For the purpose of this convention, an aircraft is considered to be in flight from the moment when power is applied for the purpose of actual takeoff until the moment when the aircraft landing run ends. It permits a claimant to pursue a claim against a foreign operator through the court in the state of residence, and resulting judgment would then be enforceable in the state of the operator. Tokyo Convention 1963. This convention provides that state of registration of an aircraft is competent to exercise jurisdiction over offences and acts committed on board. Aircraft commander is empowered to prevent certain acts committed on board an aircraft which may jeopardize the safety of an aircraft or persons and property on board. This convention also defines the unlawful seizure of an aircraft, and in the case of an anticipated or actual unlawful or forcible seizure of an aircraft in flight by a person on board, the rights and obligations of the authorities of the state in which the aircraft lands. Hague Convention 1970. This convention deals with the suppression of unlawful seizure of aircraft. Convention defines the act of unlawful seizure of aircraft and lists which contracting states have undertaken to make such offences punishable by severe penalties. The convention contains detailed provisions on the establishment of jurisdiction by state over the offence on the taking of the offender into custody and on the prosecution or extradition of the offender. Montreal Convention 1971. Montreal Convention for the Suppression of Unlawful Acts Against the Safety of Civil Aviation. It makes it an offense to attempt any of the unlawful act against the person who acts violently on board an aircraft or who destroys or damages an aircraft in service or who places a bomb or similar device on board an aircraft or who destroys or damages a navigation aid or interferes with operations or who passes false information, thus endangering an aircraft safety. The contracting states have undertaken to make these offences punishable by severe penalties.
Please like and subscribe and press the bell icon to get new video updates.